Thank you, Sophie. Thank you for inviting me today, and thank you for that introduction. I'm a barrister at Garden Court Chambers in London, and I do a lot of domestic homicide cases. I specialise in representing women who've killed their abusive intimate partners, both in the Crown Court and at appellate level. And I was asked today to speak about my work and about the Domestic Homicide Sentencing Review, which some of you may have read. It was published last year, and I'll go on to talk about some of the recommendations in that review. I've called the talk Reframing the Legal Landscape in Domestic Homicide because what I'm hoping to give you is a sort of chronological account, really, of some of the changes that have taken place over the last 30 years or so, and to look at where we are now in relation to our understanding of the issues in these cases. And so I've called the second slide Accessing Justice, both for women who kill abusive men and achieving justice for women who are killed, because a great many women are killed by their intimate partners, far more than women who kill men with whom they are or have been in an intimate relationship. And one of the things that I tried to emphasise in the Domestic Homicide Sentencing Review is the need for an underlying rationale and a consistent and comprehensive approach to the issues in these cases, and tried to identify what the issues are. I'd say that the law on domestic homicide is a developing jurisprudence. There have been a lot of recent developments, a lot of recent work from both criminologists and lawyers through the casework that we do. I'll go on to talk about it in a minute. But I wanted to, I think, show you in the course of this talk the impact of some of the case law that I've been involved in, or organisations that I'm connected to have been involved in, and which has factored into many of the proposals, or in fact all of the proposals, because there are a package of proposals in the Domestic Homicide Sentencing Review. So to start, as I've already said, the majority of domestic homicides are perpetrated by men against women. And when I came to conduct the review, I was given 120 cases which had been pre-selected by previous workers on the case, members of the Ministry of Justice. They'd been provided by the CPS, the Home Office, and so forth. There were 120 cases which had occurred between 2018 and 2020. And by way of illustration of the point I've just made, out of those 120 cases, 99 cases were cases where male perpetrators had killed their intimate female partner, or an ex-female partner, and 21 cases over those 2 years involved female perpetrators. 20 of them were women who had killed men with whom they had been or were in an intimate relationship at the time. One was of a female who had killed her female partner, and that was slightly different, but those were the statistics. And broadly speaking, those are statistics which are borne out by other research that has been done. And men and women kill, or appear to kill, for very different reasons. Men, in my view, kill often because, or usually because, they are controlling, and we'll look at some of the research that's been done on that in a minute. But women who kill are few and far between, and they tend to kill as a result of suffering domestic abuse or coercive control, which is directed to them by their male partners. And so they are often victims. They come to the criminal justice, before the criminal justice system, as victims as well as perpetrators. So they bring with them quite specific issues, and there are different issues from the issues that we deal with when we deal with men. And they're nearly always charged with and prosecuted for murder. So, for example, the Crown Prosecution Service, in my experience, don't routinely accept pleas of guilty to the lesser offence of manslaughter. There will nearly always be a murder trial. And in the course of that trial, we often rely on the partial defences. So there are, as you'll know, from your criminal law, diminished responsibility under Section 2 of the Homicide Act 1957, which was amended in 2009, and loss of control under Sections 54 to 55 of the Coroners and Justice Act 2009. And if those defences are successful, they, of course, reduce what would otherwise be murder to manslaughter. Now, the partial defences were introduced in 2009 with the parliamentary intention of affecting gender parity. Loss of control replaced the old partial defence of provocation, which existed in statutory form, at least under the Homicide Act 1957, Section 3. And the reason that was replaced was it was thought very much to favour men as opposed to women. Provocation was based on the model of male anger, typically, and it was thought through looking at the case law by academics, politicians and so forth, that men tended to kill in anger suddenly and often because of jealousy. Women, on the other hand, deliberated and couldn't, in those circumstances, avail themselves of the defence. And I cited here the case of Duffy in 1949. Duffy was a case where it was the case which determined that in order to run provocation at trial when you were being tried for murder, you had to have acted suddenly. And so any deliberation would put you out of the running for availing yourself of that defence. The facts of Duffy are interesting for several reasons. It involved a case of a wife, Renee Duffy, who killed her husband while he was asleep. She fetched an axe, hit him over the head a number of times, and Mr. Justice Devlin ruled during the trial that the killing hadn't been sudden, and so, of course, she was denied the opportunity of successfully running provocation. She was convicted of murder and sentenced to hang, but the story, it has a happy ending because her solicitor, I think it was her solicitor, ran a huge campaign and got a load of signatures, and the sentence was commuted to one of imprisonment, life imprisonment, and in fact she was released a few years later. I found it fascinating because of the facts and the contemporaneity of those facts in terms of some of the issues that we're looking at now. It was a case that involved allegations of physical abuse perpetrated towards her by the deceased. There was an issue about non-fatal strangulation, which is something the government have picked up on recently. There were allegations of sexual violence. And one of the things which was notable about the case, according to the Manchester Guardian at the time, was the matter-of-fact way in which she simply announced that she had killed her husband, and then she walked through the rain to her sister's house, where she was later arrested. There is, I've cited something that Professor Susan Edwards says here. She says if she was tried today, she would again be convicted of murder and would serve a minimum of 15 years. For anyone who's interested in that case, there's a beautiful article about it in the Criminal Law Review by Susan Edwards, just stating quite boldly the facts as she researched them. But they're significant, I think, because they are so contemporaneous, and they are facts which we see again and again, and issues again and again, which arise in the cases that we do or that we're involved in. There are a number of cases. So that was the reason that provocation was reformed. It was abolished as a partial defence, and the reason that loss of control became part of our law in 2009. Now, during the 1990s, there was a surge of feminist activism in terms of the cases that were being seen. Many men, it was thought, were being acquitted of murder on the basis of what they were saying about the relationship, about women that they were involved in. And it seemed terribly unfair that women who were being charged with murder of abusive male partners were being convicted. So I've just referred here to the Southall Black Sisters, who are and still are an active campaigning group, and some of the campaigns that they ran. And things started to change with the case of Kiranjit Ahluwalia, which I'm sure you've heard about. There she is in the middle, and there's Sarah Thornton on the left. In 1990 or thereabouts, Justice for Women, a campaigning organisation. It's not a charity, it's a campaigning organisation which campaigns to support women who have fought back against male violence. So Justice for Women was founded as well. And there were a number of significant cases which took place in the 1990s, occurred in the 1990s, which I've chosen specifically because, partly because they are significant in terms of the jurisprudence that has developed, but also because I think recently I've looked over the facts of those cases again and see many things now that we appreciate, given what we know about domestic abuse and coercive control, that weren't necessarily obvious to courts at the time. So just to take, first of all, the case of Sarah Thornton, which you may have heard about, Justice for Women case. Thornton, number one, she killed her alcoholic husband. He was jealous and violent. She suffered from a personality disorder. And one of the things that she said when she was first arrested was, "I'm going to kill him." She'd said that before she killed him. So there was a stated intent to kill him. She stabbed him when he was in a drunken state. She later said, "I wanted to kill him." And she then said, "I didn't intend to kill him. It was an accident." And I'll come back to some of the themes which come out of that later when I'm talking about the way in which I think the law should change now. But she ran diminished responsibility at her first trial. She was convicted. And it was said by the trial judge, it was said that provocative acts in the course of domestic violence over a period of time, which did not cause sudden and temporary loss of control, did not amount to provocation. So there we are. We're still at that stage, at the stage that we were at when Duffy was decided in 1949. And in the words of the trial judge, in his summing up, he said she could go out or she could go upstairs, notwithstanding the violence. Kiranjit Ahluwalia, on the other hand, had run a defence at trial that she was not intended serious harm, and she had tried to rely on the old law of provocation. She'd set fire to her husband, who was violent and abusive, when he was asleep. Now, her appeal, one of these early cases, which was precipitated by campaigns by the Southall Black Sisters, she advanced a successful defence of diminished responsibility. So provocation hadn't worked, but diminished responsibility worked on appeal. And she relied on an endogenous depression and battered women syndrome as a part of the sort of mitigatory aspect of diminished responsibility. And the court held in that case that a gap between the provocative act by the deceased and the conduct of the defendant didn't necessarily negate provocation. And so courts were starting, it seemed, to open up in terms of the suddenness that was necessary to run the partial defence of provocation. But nevertheless, the case was won on the basis of diminished responsibility, depression, and what I would now say is the outdated battered woman syndrome, which I'm sure you've heard about, based on learned helplessness and sort of recurring cycles within a violent relationship. Then came the case of Emma Humphreys. This was another Justice for Women case. So it was precipitated by a campaign. She had been convicted. She was very young. I think she was 17 at the time, if I recall rightly. She'd been convicted of murder. She had murdered her pimp, who she was living with. And what came out of her appeal, she won her appeal on the basis of provocation. And it was really a seminal case because in that judgment, the Court of Appeal allowed for the prospect of what we call cumulative provocation against a background of domestic abuse. And so it was first, with the exception of CUHRLS case, it was first introduced into law, and the case was won on the basis of provocation. The trial judge had been wrong merely to focus on the incident at the time of the killing, because that was something which didn't seem on its own to be that provocative. But it was the whole history of the abuse that she'd suffered that was relevant. And what the Court of Appeal said in Humphreys was that it was incumbent on the trial judge to analyse all the strands of the provocative actions on the part of the deceased, the whole history, and indeed on other things that the defendant had suffered from. So a mere historical recital of the facts was always going to be insufficient. And although that is something that had been applied in another case, in the case of Stewart, which was cited in that case, it was the first time really that the whole issue of cumulative provocation was introduced into our law. So Thornton number 2, Sarah Thornton's case was on the basis of campaigns, was referred back to the Court of Appeal, and she won her second appeal in 1996. Again, as I said before, she suffered from a personality disorder. She won it on the basis of the outdated concept of battered woman syndrome. Relevant characteristics going to the reasonable person test, that's since been overruled in Holly. It's not relevant now. But the basis of appeal being allowed meant there was an emphasis on her mental health condition and on battered women syndrome. And it wasn't an emphasis at all on what I would now refer to as structural inequality and, in fact, the entrapment which I would argue leads women often to kill their intimate partners. Kirsty Scamp is another Justice for Women case. Interesting. It was one of the final cases where provocation had been argued at trial. She had run self-defence at trial. She, again, was very young. I think she was just 18 at the time of the trial. She'd run self-defence at trial. Amidst a history of abuse, she'd stabbed her partner. There were a number of acts of abusive behaviour, violent behaviour towards her by him. She'd been subjected to domestic abuse all her life because she'd witnessed it throughout her childhood. She, like many of the other women we support in Justice for Women, had been advised there were no grounds of appeal by the trial legal team. And we appealed it on the basis of the decision in Humphreys, so on the basis of cumulative provocation. The judge had not, though he'd left provocation to the jury, notwithstanding that she was running self-defence, he had not, it was said, argued, analysed the history of the violence which had been perpetrated towards her, and not looked at the previous incidents as forming part of the cumulative provocation. There was no mental health diagnosis, so it was run purely on the basis of provocation. And then, as I've said, the Coroners and Justice Act was introduced into law in terms of looking at introducing the new partial defences, which I referred to earlier. And I think the question now, or the question most recently, has been, are those partial defences working for women who kill? And is there a disconnect between the present law and what we now understand about domestic abuse? So just by way of introduction, the partial defence of loss of control is incredibly complicated, and there's an incredibly high statutory threshold which needs to be achieved. Obviously, the burden is on the prosecution to negate it if the defendant is able to raise it. But in order for that to be left to the jury, there needs to be what can be construed as a loss of control in the first place. So there needs to be something which is viewed by the court as a loss of control. There's still no real definition in law as to what a loss of control is, so that can be difficult in some cases. There needs to be a trigger to that loss of control, which either has to be a fear of serious violence or a justifiable sense of being seriously wronged. And the third question is, might a person of the defendant's age and sex, so it's only age and sex that are relevant necessarily to that, in the circumstances of the defendant have acted as the defendant did. So note, it's not a psychiatric defence. There is minimal relevance of psychiatric and or psychological conditions. They can be said to go to the gravity of the trigger, if indeed there is a trigger. But the issue is it was enacted without any consideration of the fact that domestic abuse is underpinned by controlling and coercive behaviour, which is now is the way increasingly we understand domestic abuse. On the upside, under the present law, there's no requirement for the loss of control to be sudden. So the cases that I mentioned earlier were put into statutory form. There can be deliberation, there can be cumulative issues as to cumulative facts going to the loss of control and going to the trigger as well. But it was largely introduced, not just for women to be able to rely on it, because it's thought that it couldn't rely on the old defence of provocation, as I've explained, but to stop men who were relying on it for reasons of jealousy and so forth. And by and large, looking at the cases we looked at in the Domestic Homicide Sentencing Review, I would say it's been successful, probably, in that regard. We didn't find a single case where a man who had killed his intimate female partner had successfully relied on loss of control. But the issue is, does it work for women who kill? Did you want to ask a question?
Yeah. I'm curious to know, so age and sex are considered not. Why do other characteristics like disability or rape?
So they can be considered for the loss of control and for the trigger, but not for the circumstance, not for the whether or not a person of the defendant's age and sex in the circumstances could be, because they were initially, I skipped over it before, but in the House of Lords case of Smith years ago now, it was determined that they could be relevant to the third question in provocation, which is broadly similar to the question here, C, 54(1)C that we've got here. But that was overruled in Holly, and the reason it was overruled was because, in effect, it imbues the reasonable person with the specific characteristics of somebody different. So that's what happened. But in fact, if it's looked at, I mean, it's a really interesting question, because if it's looked at, if we try to translate much of what we know into the Act, it's relevant to the gravity of the trigger. So, for example, if somebody is provoking somebody because they've got mental health conditions, then it would be relevant to that. If somebody with, say, a particular mental health condition lost control, was more likely to react, to see the threat, than somebody who didn't have that condition, then it would be relevant to that. But it's not relevant to the reasonable person test. And I suppose that's one of the issues. I've said here that the prosecution never accept a plea to manslaughter on the basis of loss of control, because they always seem to say, well, that's a matter for the jury, isn't it? It's whether the reasonable person would have done it. So you can, of course, ought to consider somebody's circumstances within that third question. So, but often, I'll refer to a case at the end of the talk, but often they all get merged into one. But ideally, they ought to be separated out, because there's nothing to stop somebody's circumstances being incorporated into that question.
Thank you.
So I was saying that the new defences were introduced. I think they came into force in 2010. They were largely based on the work of the Law Commission, which started in 2003. So the sort of feelings that the law wasn't working for women and was overworking, as it were, for men, caused referrals to the Law Commission starting in 2003, where they looked at the partial defences and then went on to look at the whole of the law of murder. And then the Ministry of Justice did their own project and came up with the law as we know it is now. But during the course of the work that was done, and it was done over a considerable period of time, starting in 2003, and I think finishing in 2006, there was no reference at all to what we now know to be controlling and coercive behaviour. So as I've said, it was all focused on the idea of battered women syndrome, that these women somehow had something wrong with them, that they were learned helpless. It was all about learned helplessness and being trapped in a cycle. And controlling and coercive behaviour simply didn't come into it. And in fact, if you look at Hansard, there was no mention of coercive and controlling behaviour until 2012, when, interestingly, Women's Aid had asked a question about sentencing. So it simply developed separately from what we know. But Evan Stark published his seminal work, Coercive Control, How Men Entrap Women in Personal Life, in 2007. And in that book, he gave a definition of coercive control. So coercive control entails a malevolent course of conduct that subordinates women to an alien will by violating their physical integrity, domestic violence, denying them respect and autonomy, intimidation, depriving them of social connectedness, isolation, and appropriating or denying them access to the resources for personhood and citizenship control. And what he said was nothing men experience in the normal course of their everyday lives resembles this conspicuous form of subjugation. And in effect, just put broadly, he uses really the concepts of hostage taking, being under siege, and so forth for explaining why women become entrapped, mostly women. I'm not saying it doesn't happen to men, but mostly the victims are women, become entrapped in relationships. And that came about, or was published in 2007, obviously, and we now have Section 76 of the Serious Crime Act. That got the royal assent on the 3rd of March 2015. And we have here a sort of loose definition of the offence, so that it's an offence of controlling and coercive behaviour. Coercive and controlling behaviour, and it's interesting because what the law sought to do for the first time, really, there's no other offence like it. I don't think there's any other offence where the actus reus on its own is something which is not necessarily completely, it can be completely lawful. And it was based on Stark's clinical concept of coercive control. It aimed to translate it into something which is actionable in law. There's been a lot of academic criticism about how you prove this offence and how difficult it is to prove. Nevertheless, it's on the statute books. Section 76 is gender neutral, of course, which Stark's definition wasn't. And the harm is, or the consequence is a fear of violence or an effect on day-to-day life. Now, the maximum sentence is 5 years. The question I've just put here as a question at the bottom, has the law really recognised a new legal harm of entrapment? I'm not sure that it has. And we need to look to the case law, which has developed subsequently for that. Case law and murder in particular. And there is all sorts of statutory guidance. I'm going to skip through this because it's there. I mean, it's there as an aid to agencies in terms of looking for the offence and prosecuting the offence. It's quite prescriptive, and it's supposed to enable police and so forth to be able to identify offences of coercive control And so it's things like monitoring, depriving people of their basic needs and so forth. And there are examples which are given continually of the types of behaviour. So generic types of behaviour like putting people down or telling them they're worthless, preventing access to transport, preventing access to phones is something we see quite a lot. And obviously assault and criminal damage and so forth. So 2015 was when we started as a Justice for Women case doing work on the case of Sally Challen, which you've probably all heard of. She was somebody who was convicted of murder, I think, back in 2011. And it took a long time, really, to try and sort out what the issues in that case were. They'd all been there for everyone to see from the outset, but it hadn't really been interpreted as we ended up being able to interpret it in the Court of Appeals. So at trial in 2000, she hit her husband over the head with a hammer about 18 times in the course of a long history where they had become divorced or were going to be divorced, and then they were going to get back together again because she felt that she had no identity separate from that of her husband, and she couldn't live without him. And she killed him. And all of the evidence, she ran diminished responsibility at her first trial on the basis that she was suffering from a depressive disorder, depression, mild to moderate depression, which is actually it's not necessarily mild in medical terms, but she was suffering from depression. And all the evidence which went to his controlling and coercive behaviour had been available at the time of the trial, but the concept of coercive control and the legal harm, which is the consequence of it, which I would argue is entrapment, hadn't been recognised. And in fact, she hadn't run. It was one of was it 2002? Yeah, I think it was 2011. The offence had been committed before because it was run under the old law. So it was a case of provocation, but the original team didn't think that provocation could be run because there was no evidence of violence. In fact, there was some evidence of violence, but it wasn't what they would have expected to see in that type of case. Anyway, we applied for leave to appeal that case and were refused leave by the single judge. But I renewed the application for leave in front of the full court, and they said, Lady Justice Rafferty said, well, all right, we're going to give you an opportunity to argue this. We want to know all about coercive control, because there was a bit of argy-bargy going on about whether or not Stark's work was in the had been properly promulgated at the time of the trial, and they were saying, well, he's published in 2007, so why was and we were saying, well, no one knew about it. It wasn't part of our discourse, criminal law discourse. So they said, all right, well, we're going to give you a chance to argue it on appeal. So we had an appeal, and we called Evan Stark, Professor Stark, in the course of that appeal. His evidence wasn't admitted under Section 23 of the Criminal Appeal Act 1968, but the court heard his evidence, and he was examined and cross-examined. And we also called a fresh psychiatrist and the previous psychiatrist who, having seen Evan Stark's report and his evidence, said, well, yes, I agree that this is a case of coercive control. There was some fresh psychiatric evidence which had been obtained as a result of what looked to be a serious mood disorder or a manic episode in prison. And what that threw up was that she was diagnosed with a dependent personality disorder, which fitted entirely with her history. And it was not coercive control on its own necessarily. It wasn't psychiatric evidence on its own. What the factual matrix threw up was the interface between the psychiatric evidence which existed and the coercive control. And it was that interface that was key. And the Court of Appeal in the full appeal hearing accepted that had the jury known or had the evidence of coercive control, had it been framed in the way it was framed with our better understanding of domestic abuse through the lens of coercive control, then the jury may have come to a different decision. And so in doing that, they accepted, I would argue, the move away from battered women syndrome and an incident approach, an incident-based approach, and looked to the pattern of behaviour, which of course leads to entrapment. And it's a really, it's an interesting case, not necessarily reflected all in the judgment, but the issues there were issues that we see or have seen over the years again and again. So she was portrayed in the media as being a jealous wife. She was jealous of his affairs. This was retaliation. There was the issue about why she'd hit him. It was the trigger in our argument because he of the way he was behaving at the time. They were portrayed as trivial reasons, and she was presented as being a callous woman because in court she was so disconnected from the situation that she was in. She was still, like many women actually, in shock at what had happened and depressed. She came over during the course of cross-examination, I understand, as being quite cold and not able to really answer the questions that were being put. But once we looked at it through the lens of controlling and coercive behaviour, we were able to reframe it. So the concept of gaslighting, which is manipulating someone by psychological means into doubting their own sanity, was something which changed what the perception of her, because she'd been accused of stalking and spying, because he was having affairs and constantly denying that he was having affairs. And that was reframed as reality checking. So that's just one example of the way in which we were able to reframe that. So I said that the sort of definitions, the aids to understanding coercive control in terms of Section 76 of the Serious Crime Act was quite prescriptive. And I think that what comes out of the cases, in particular Sally Challen's case and the cases that we've looked at subsequently, is that the concept of coercive control is really a heuristic tool. It's a way that we can analyse the factual matrix of a lot of the cases that we look at and work on. And it's often, just to condense it quickly, it's often described as being something that's a bespoke form of abuse, because very often an abuser will discern something which makes a victim vulnerable and just use that to try and control them. It throws up and enables us to understand issues of intersectionality. For example, in the course of the Domestic Homicide Sentencing review, we found examples of women who'd suffered coercive control because they were migrant women and had been abused by their intimate partners because, for example, she hadn't supported his application, immigration application. We know that many migrant women find it hard to disclose abuse, to seek help. They're isolated and so forth. And other issues of discrimination, all of which go to compound the ability of somebody, should they be so minded, to control those women. And the Centre for Women's Justice published I think it was in 2021, a paper based on research of cases which took place over 10 years on women who kill. The full title is Women Who Kill, Defending Women We Might Otherwise Be Burying, and looking at some of the issues that they faced in court, and many of the issues of discrimination. For example, there were women who didn't have interpreters that spoke their dialect, the all-male legal teams and so forth. And that was the first piece of research, long-term research, that looked at the way in which those women in particular were represented. So Farisha Martin is another case post-Challen, and probably a case on point, She won her appeal in 2020. She was convicted after trial. She had a trial in which she was running self-defence, but won her appeal later on the basis of diminished responsibility and loss of control. Loss of control had in fact been left to the jury. There was no psychiatric report obtained by her trial solicitors before trial. She had an all-male legal team. There was latterly psychiatric and psychological evidence going to a diagnosis of post-traumatic stress disorder because of things that had been happening in the relationship. Once again, leave was refused by, so I drafted grounds, in fact, before Challen. So the original grounds predated the hearing in Challen, and leave was refused by the single judge. But the case was renewed before the full court. And I was able to look at it, I suppose, with fresh eyes, having argued Challen. And in renewal, the Court of Appeal said that it was the paradigm case of coercive control, all of which had been missed in the first instance. As I've said, the appeal was allowed. There was a retrial. The prosecution wouldn't accept a plea to loss of control. They wouldn't accept a plea to diminished responsibility. They insisted on retrying her for murder, and that collapsed on day 2 when they accepted a plea to unlawful act and manslaughter. There'd been an issue in the original trial. She'd said that the deceased had been strangling her at the time that she stabbed him, and at her original trial, there'd been an agreed fact that she had no marks on her neck consistent with strangulation. At the retrial, we asked for her custody photograph, and the custody photograph, it was agreed by the pathologist, showed marks on the neck. So immediately she'd gone into custody, she did have those red marks on the neck, which were consistent with the allegations she'd always made, she lied in her first interview, but made in her subsequent interviews, that she was being strangled, and at trial that she was being strangled or had been strangled shortly before she stabbed the deceased. So that hadn't been disclosed. So she was then sentenced on the basis of unlawful manslaughter. And the reason I cite the case is because of this. Coercive control and entrapment, I think, best reflects the experience of women. It gives them a language for something that they've experienced. We haven't had a real language before, namely a pattern of acts perpetrated against her, things said, which comprise strands of behaviour which go to entrapment. And now, Farisha Martin had been refused leave to appeal in the first instance because it was said she couldn't rely on allegations of domestic abuse or coercive control post-trial. And she should have mentioned these things before trial. When we looked at the papers, she had, in fact, written to her legal advisors. So she was unable to disclose many of the things that had happened to her. But she had written a long letter. And in that letter, she had said, she had referred to the following: the deceased's jealousy, which got worse as the relationship progressed, the deceased's continual reference to her ex-boyfriends in the context of verbal abuse and name-calling, being physically violent if she was late home or when she was pregnant, isolating her from her mother and her friends, telling her that she was fat and no one would want her, criminally damaging her possessions, and she didn't have many of them, particularly if she did not come home when he wanted her to, and controlling her by dictating where she should go and who she could be with and what time she could be in, asking to see her phone and so forth, and making her believe that the violence was her fault by saying that he was just joking, and gaslighting her by telling her that when he had been violent, by physically holding her down and sitting on her, that he was messing about. So all of that evidence was available at her first trial. She wrote that down, but it was overlooked. And what Challen has given us is the lens that we now have to be able to analyse cases properly. And the same can be said of Kuranjit Ahluwalia. And I've put here a quotation. We use this when we argued Challen to try and demonstrate that it was there in plain sight, but we simply weren't appreciating domestic abuse in the way that we were able to, given the concept of coercive control. So in the appeal of Ahluwalia, Lord Taylor read out a letter that she had written to the deceased before she killed him. Deepak, if you come back, I promise I won't touch black coffee again. I won't go town every week. I won't eat green chili. I'm ready to leave Chandikar and all my friends. I won't go near Degudi Mohan's house again. Even I'm not going to attend Bully's wedding. I eat too much all the time so I can get fat. I won't laugh if you don't like. I won't dye my hair even. I don't go to my neighbour's house. I won't ask you for any help. And Lord Taylor referred to the sort of complete state of subjugation she had found herself in. Nevertheless, that appeal, as I said, was won on the basis of diminished responsibility. So it was Susan Odwards who pointed that out in the article that I've referred to there, Coercion and Compulsion and Reimagining Crimes and Defences. And I think it's fascinating because it demonstrates the point that the evidence was there all along. It's just our appreciation of the way in which domestic abuse works that's changed. So, of course, the next significant development was the introduction of the Domestic Abuse Act in 2021, aimed to give and gives a definition of domestic abuse, includes behaviour such as physical or sexual violence, violent or threatening behaviour, controlling or coercive behaviour, economic abuse, psychological, emotional or other abuse. And it doesn't matter whether it's a single incident or a course of conduct, because, of course, coercive control is largely a course of conduct designed to achieve the ends it achieves. And in writing the Domestic Homicide Sentencing Review, I chose to use coercive control as opposed to domestic abuse, because coercive control potentially, of course, includes all of those other wrongs which are cited in the Domestic Abuse Act. Meanwhile, other research, which is particularly important, I think, particularly important when we look at cases of femicide, of which we've seen, because of the statistics, there are so many more men, as I've said, who kill their intimate partners. And the research that's based on coercive control, as Evan Stark has expounded it, is something which has formed the basis of the work of criminologist, Professor Jane Monckton-Smith. So she published, I think in 2020, her article, Intimate Partner Femicide, using Foucauldian analysis to track an 8-stage relationship progression to homicide. And what she did was take a number of cases and look at those cases and look at the themes in those cases and look at the facts in those cases, and was able to design a temporal sequencing pattern for why and how women who are in abusive relationships come to be murdered by their male partners. And she identified 8 steps to homicide. So the first is pre-relationship. By that, it was usually the case that the man who ended up committing murder or manslaughter usually had some sort of history for controlling behaviour. There was then the early relationship, and that would be a relationship where it would things would happen incredibly quickly. So quick pregnancy, quick moving in. And I've done a number of cases, I have to say, where a relationship starts and suddenly a man moves into a woman's house and gets his feet under the table and then starts sort of behaving in a controlling way. And then there would be earlier, so that was the early relationship. Then there'll be behaviour in the relationship, which is when you'll often see controlling and coercive behaviour. And then you will have a trigger event. And that trigger event is not always, but more, it's something significant, but not always, but more often than not, and certainly appeared to be the case in the cases that we looked at in the Domestic Homicide Sentencing Review, she wanting to leave the relationship. So the thought that the relationship and the control was going to come to an end. And then there would be an escalation in control, a change in thinking, which would move to planning, which would end up in homicide. And in many, if not all of the cases where a woman is murdered by a controlling man, with whom she's in or has been in a relationship, you will find that those 8 steps play out, and that they do provide a sequence as to how that relationship will end in homicide. And it's with the aim of risk prevention that the work has been done. So if we understand how these relationships work, then of course we can understand the risk factors, and we can understand and try and stop the danger that the relationships place these women in. And she's also developed one, building a temporal sequence for strategies to reduce the risk for suicide and intervention in suicide, which deals with honour killing and partner suicide, because very often there will be a similar pattern which will involve coercive control, which will end up with the victim committing suicide. And that, of course, is one of the things about controlling coercive behaviour, is that very often it's so invidious. It creates situations where women feel as if they're somehow complicit in the abuse that they're suffering, because they end up making decisions because it's easier. If somebody kicks off every time your friends come round, it's easier not to invite your friends round than to have them kicking off. And we see how slowly and by accretion control can take hold. And so looking at those developments and looking at that work, we are moving, I hope, or I would wish that we would move to a more forensic understanding of domestic abuse. So we've got the definition of the Domestic Abuse Act, but all too often there's a sort of woolly approach, I think, to the whole concept of domestic abuse. And we see that in many of the cases that I do. So the relationship is not seen necessarily as controlling, it's seen as toxic or volatile, as opposed to one that's characterised by coercive control, or something that Jane Monckton Smith refers to as control and resistance. So if you continue to resist control, then the outsider may very often think, well, this is a really volatile and toxic relationship. They're always at each other. But eventually, in many of the relationships, women just desist and don't try and resist. And that leads to an extreme state of entrapment. And one of the issues is, I think, do mental health conditions, I've talked about psychiatry and psychology, and I've talked about cases in the past being won on the basis of things like battered women syndrome, and the idea that somebody is suffering, they must be suffering from mental illness because they've killed. And one of the questions I think that the whole concept of coercive control throws up is whether or not somebody is vulnerable to coercive control, perhaps because they suffer from a condition, or is it because they are suffering from coercive control, that they have a condition such as post-traumatic stress disorder, or is it both? And it, as we demonstrated in the case of Sally Challen, it can be both. It can be the interface between the two things. And one of the questions insofar as diminished responsibility is concerned, because the statutory hurdle is quite high in that partial defence, is are those conditions, which are often an output of coercive control, enough to satisfy the high statutory threshold, or will they do so if we have a greater understanding of coercive control and, by turn, a more forensic approach to domestic abuse? And one of the problems in fighting these cases is that psychiatrists and psychologists who have to be instructed, or psychiatrists certainly have to be instructed in cases of diminished responsibility, as they don't have necessarily a detailed understanding of coercive control. And there's still emphasis on the immediate violence as opposed to the wrong of entrapment, because the wrong of entrapment is not recognised really as a wrong in law. So one of the conclusions could be that the Domestic Abuse Act at the moment is not enough to give us that proper forensic, hard-nosed forensic understanding to what domestic abuse is. So here's a case. I've just referred to this case study. This largely because we make changes incrementally, bit by bit. But this was a case in which we were able to call Professor Monckton-Smith to give expert evidence. So HK was charged with the murder of her partner. The prosecution refused to accept a plea to manslaughter. She had mild mental health difficulties, so anxiety and depression. All the text messages between the two of them were produced at trial, and she was presented as somebody who gave as good as she got. That's an expression that comes up a lot in these types of cases. And the prosecution adopted the messages from the deceased at face value, and the messages from the deceased were designed, in our view of the case, were designed to attack her where she was vulnerable. The one thing she had in her life was that she was a mother. She was a good mother. She was continually told she was a bad mother. There were messages from him pertaining to jealousy. And she stabbed him, and she maintained at the time of her arrest, I only threw the knife. That takes us back. That's something we hear quite a lot in these cases. It was an accident. I didn't intend to. I only threw the knife and so forth. It takes us back to those earlier cases, or the earlier case of Thornton. In fact, there was a level of dissociation which we often see. We saw that in the case of Fry Martin, where somebody under extreme stress and emotional arousal just blacks out and they just don't remember exactly what happened. She may have thrown a knife, we argued. She may remember throwing the knife, but she doesn't remember stabbing him. So in that case, the judge allowed us to call Jane Monckton-Smith, who gave expert evidence. She was allowed to give expert evidence on coercive control and the way in which coercive control works. It was incredibly helpful, but that's as far as she was allowed to go. Because the intimate partner femicide timeline doesn't deal specifically with cases of women who kill abusive men. It's all the other way around, and it deals with temporal sequencing for men who kill women. So the argument, I've had trials where it's not being allowed in, that sort of expert evidence. Usually the view is that we can only call psychiatrists and psychologists. We can't call someone who knows about coercive control. And the concept, and that can make a real difference. So I've had it admitted and not admitted. So that's a relevant change which could come about. So more of the developments post-Challen. Now we get on to the Domestic Homicide Sentencing Review. I'm just going to check the time. And that was commissioned by Robert Butler and the Lord Chancellor in 2021. It was as a result of a campaign by Julie Deavy and Carol Gould, whose daughters were tragically murdered by their boyfriends, and together with that, a letter from the Victims Commissioner and the Domestic Abuse Commissioner about the way in which women were let down in the criminal justice system. Carol Gould and Julie Deavy's daughters, Poppy and Ellie, were murdered by their boyfriends and viciously attacked, being stabbed many times, many more times than was necessary to cause death. Both of them were in the process of leaving the relationship when that happened. And the reason that the campaign started and which precipitated that the report and another ongoing campaign at the moment is because of the discrepancies in sentencing for murder under Schedule 21 to the Sentencing Act. So very broadly, paragraph 4 of Schedule 21, it's divided into paragraphs. So for a very high culpability murder, for example, the murder of a child or something planned, or the murder of two people, maybe a whole life term, for murder of somebody with protected characteristics, there's a 30-year term, and for example, use of a firearm, a 30-year term. If you take a weapon to the scene, intending to use it, and then use it in a murder, then you are liable for a 25-year term. if you murder somebody other than outside of those parameters, then the starting point of the minimum term is 15 years. And it can go obviously up and down. You can move between categories. But because there was a discrepancy between 15 years for, say, a murder which happens in the home where a knife is just picked up in the kitchen, and a murder which happens on the street, there's a discrepancy of 10 years. This campaign has come about. And so when I was instructed to do the review, there was, and there still is in fact, a demand for increased sentences in domestic murder cases. But of course, the reason I was asked to do it is there's an unacknowledged tension because women who kill are also victims. So it's all very well, you can increase starting points if that's what you really want to do, and say, well, everyone should be liable for a 25-year starting point in the case of a domestic homicide. But why should a woman who is resisting violence from a coercive controlling man and kills in the process also be liable to a 25-year plus starting point? And that is the difficulty. It's about needing to avoid unintended consequences. So I think I've already covered this. The point of the review broadly was to look at the disparity in starting points between the 15-year minimum term and the 25-year minimum term, and the avoidance of unintended consequences and the ramifications for women who kill. As I've said, I had 120 cases for analysis. And it seemed to us that, and I maintain this, that the whole starting points for taking a knife or a weapon to the scene and using it in a murder being 25-year term, it was something that was introduced after the introduction of Schedule 21 by the government, who wanted to stop young people from taking knives onto the streets. It came in on the back of a hard case. And is quite different from all the other categories in the schedule because it doesn't deal with the vulnerability of the victim. It simply deals with the way in which the killing has taken place. And looking at history, going back and looking at the history of the legislation, it was quite clear that domestic murders had never been given any particular consideration. They would normally start at 15 years, unless somebody could be said to have taken a knife to the scene, say taken a knife to the front drive out of the house, then of course it starts at 25 years. It's completely anomalous. But it seemed to be a complete red herring because one of the things that struck me when I started looking at it was something that Julie Deavy said, which is, why should somebody who takes a knife to the scene and stabs somebody in the street and stabs them only once get a 25-year starting point, and somebody who commits a domestic murder and, say, stabs somebody 29 times or 70 times and then strangles them as well, why should they have a 15-year starting point when the murder has happened just because they haven't taken a weapon to the scene? But the reality is that the harms which are pertinent to domestic, or which follow domestic murder, are very specific, and they're very different from the harms which occur in terms of, say, gang killings and stabbings in the street and so forth. And so we set about, first of all, looking at those two cases which have been put before us, those because there was a real grievance over the sentences, which were perfectly proper in themselves according to the law, which had been imposed on the assailants of those two young women. We looked at those cases first of all, and when we analysed the facts, there were the indicia. We could find the indicia of coercive control. So, for example, in one of the cases, there was a lack of individuation. She was leaving. There was jealous. There'd been some stalking. And the other case, Ellie Gould was very young, but there was still control, there was still jealousy. And in both cases, both young women were trying to end the relationship, so it was at the end of the relationship. And in both cases, there was what I termed overkill, and that's a term that I took from the femicide census. It wasn't a term which was known to law or recognised in law prior to this work, and so they've been, really brutally killed, stabbed many, many times, far more than was necessary to affect death. And so it seemed to me that overkill in particular was one of the real harms that it sometimes occurs, or often occurs, in fact, in these cases. And we went on to analyse, whether there was overkill, whether there was end of the relationship, whether there was coercive control, could be said to be in all of the cases that we looked at. And we found that there was, in the majority or in quite a sizable number of the cases where men had killed their female partners. And so one of the ways that we sought to resolve, or the paper seeks to resolve, that tension between the need to avoid unintended consequences and higher sentences for women who are simply fighting back from male violence, and making sure that people are properly sentenced for the offences that they commit, or men are properly sentenced for the offences that they commit, was to adopt the coercive control model. So this is the latest way in which the model, which we managed to look at in Challen and bring into law, into our criminal discourse, not bring into law, but bring into our criminal discourse in Challen, has become useful for this. And the reason we chose it was it's based on a restriction of liberty which reflects pre-existing gender equality. So it's usually women who are affected. It underpins, and I think the general consensus now amongst those working in this area is that it underpins domestic abuse. Domestic abuse is far better understood through that prism. And women are more often victims because, of course, it takes place within a forum of intimacy and often revolves around things that are traditionally seen as women's work, and it thrives against a background of structural inequality. So all the constituents, as I've said, of domestic abuse are already incorporated into the pattern of coercive and controlling behaviour, and it's capable of both aggravating and mitigating a killing. So that's how we came to make the recommendation we did. Prior to that, we made recommendations that there should be a proper system for analysis of these types of cases, because there isn't at the moment, and that there should be proper training, and it should be mandatory. I won't read them out because they're there. It should be mandatory for all lawyers and judges to have training on understanding and applying the concept of coercive control. And the reasons for collecting the information that they're set out there, but it enables us to understand the themes which apply, which occur again and again in these cases. And there's also a generally held, I found, mistaken assumption sometimes within the criminal justice system that coercive control, well, it's just a matter of common sense. We all know what it is. There's no need to go into it in any depth. It's all up there. It's all, but it's about applying it to a particular factual matrix, as I hope I've already expressed. And of course, the framework where an expert is called on that, it can assist in these types of cases. There is a domestic abuse direction now used, which has come out of some of the cases that we've done on myths and stereotypes and not being sucked into myths and stereotypes. It's routinely given to juries now, and is in the compendium. As I've said, it's often missed, and so having proper analysis, a proper basis for analysis of what takes place, it is important. And the government response to recommendations 1 or 2 has been, they'll have a central library for domestic homicide reviews, which is it's quite a good response, because domestic homicide reviews, they don't happen in all cases, but often happen, and they really go into much more detail about these cases and interviewing people and so forth than happens in the criminal courts a lot. The CPS have committed to training, and I know that that is taking place. I don't know about the judiciary. The Judicial College has the locus on judicial training, so I don't know what, if anything, is happening there. But the main thing that we proposed in terms of the principal reason that we were asked to look at Schedule 21 and the whole issue of taking the knife to the scene is that we said it should be simply disapplied. in circumstances where we are dealing with domestic murder, because, as I've already said, it denotes a starting point where the vulnerability of the victim's not really given any consideration at all, and the harms, as we've analysed them, are completely different. The emphasis should be on the harms and punishing or ascribing culpability to someone who commits and causes those harms. And of course, we recommended more generally that there should be a specialist approach to domestic murders, which hasn't happened to point. Not necessarily that it should be a new starting point, but the seriousness should be ascribed to them by way of applying the coercive control model, which is the best gender-neutral way of dealing with it. And the government response has been not to act on recommendation 3. They don't want to disapply the issue on taking the knife to the scene. In fact, their response has been to hold a fresh consultation on the length of sentences. So this is a consultation, I think it closes on the 4th of March. Anyone can respond to it. The questions are very narrow. Should a starting point higher than 15 years be applied in the case of domestic murder? And if so, what should it be? Should there be a higher starting point, and what should it be? Of course, what we've argued in the homicide review, a domestic homicide sentencing review, is that if you look at those harms and you have aggravating factors in the schedule of, no trial is complete without me knocking over the water. If you have, if you apply those aggravating features, and if you look at overkill and make that an aggravating feature, then the sentences will go up if those things have happened. So you'll get to the same result. So you don't need to just have higher sentences. But that's one of the questions that the MOJ consultation has asked. I think another one is, should there be, should cases where there's been coercive control be excluded, and where there's been serious, should this occur in cases where there's been serious coercive control? And it would be far too difficult to get the courts to decide what was serious and what's not, given what we've said about the way in which it works. And I think one of the other questions is, should there be a 25-year starting point for the use of a weapon, full stop? So if a murder is committed with the use of a weapon, should there be a 25-year starting point? And I say no, because all women tend to use weapons when they commit murders. It wouldn't be a murder without, because they wouldn't be able to kill someone much stronger, physically stronger than them, without the use of a weapon. And we also made recommendations on strangulation, which I'll talk about in a minute. So recommendation 4 has been adopted in a piecemeal way. As I've said, the real issue is the wider harms. So the wider harms are end of the relationship, someone trying to get out of the relationship, because that really, really sort of presents the issue of entrapment in acute form. Overkill, which is gratuitous violence in excess of that which is needed to kill. Jealousy, and strangulation. Strangulation is highly gendered. In all of the cases that we looked at, I think about a quarter of them, I can't quite remember the figures, but involved men who had strangled their female partner, either as the primary cause of death or during the course of the attack. There was only one case where, in fact, the woman that killed her female partner had strangled her, had strangled her manually. But other than that, women don't kill by strangulation, or very rarely. So it's highly gendered. It's a highly gendered way of killing, something which needs to be taken into account when you're looking at how to punish these crimes. So coercive control is aggravating and mitigation, as mitigating was one of the recommendations. End of the relationship, someone trying to leave, should be an aggravating factor. We made another recommendation, 7. It's set out here. I'm not going to spend much time on that. It's simply to achieve consistency. The arguments are in the paper, but it's to achieve consistency with the law and on loss of control. And overkill, we recommended, should be identified in law as a specific legal harm. It should be an aggravating factor. And the reasons being, it's all too often a feature of these cases where women have been killed by controlling men. It's highly distressing for secondary victims, for their families, to hear about them being killed in that way, as if it's not bad enough that they've been murdered. It's redolent of violent pornography. It's about the total obliteration of a woman's body. And women tend to be victims as well as perpetrators, as I said. Occasionally, they might deploy overkill. I think we found one case of overkill. But if coercive control is also a mitigating factor, then there's no reason why that would necessarily, or hopefully there's no reason why that would necessarily work against women. And in the paper, I explain in more detail what Evan Stark says about that. But very often when women kill in that way, it's if they're killing their abuser, it's about destroying the image, or what Stark calls the imago. And in the words of one of the people that came to our focus groups, almost to make sure that they're dead, it's about obliterating the past and breaking free of the entrapment. So where we've got to, so the government have adopted coercive control as both aggravating and mitigating factors. Overkill has become an aggravating factor. The wording, I think, took a bit of time for them to decide, but the use of sustained and excessive violence towards the victim, I think, is the wording. It's all been adopted by secondary legislation. Clause 24, that's wrong, isn't it? Criminal Justice, it should be the Criminal Justice Bill 2023, so we'll have to change that. But Clause 24, when I last looked, was the clause which dealt with aggravation and leaving a killing at the end of the relationship becoming an aggravating factor. I don't know why all these changes have been introduced in such a piecemeal way and not in one piece of legislation, but they've committed to that. Whether or not they will run out of time in terms of that bill going through, I don't know, but it's certainly there and the intention is to do it. Now, strangulation, and I'm nearly finished, but strangulation, we recommended that should also be an aggravating factor when somebody had been killed by means of strangulation. And we recommended that the use of a weapon in domestic murders need not necessarily be seen as an aggravating factor. Neither of those, the reasons were strangulation, as I said, is really gendered. It's almost normalised in many senses culturally now in terms of pornography and so forth. Women who kill nearly always use a weapon, and certainly all of them did in the research that we did. Strangulation is not to be an aggravating factor. The government says that will place too much emphasis on the mode of killing. And there's no proposal to adopt the proposition that the use of a weapon should not be an aggravating factor. So we go back to the, yes, I've said see slide 40 on the ongoing consultation. If you make it a 25-year starting point, because a weapon is being used, where does that leave us in terms of what we know about the way in which these murders are committed? So Jane Monckton-Smith's work makes the point, which I think is now becoming accepted, that many of the murders of women by men are planned. So if you look at the temporal sequencing we were talking about, you can see there's a change of thinking, there's the planning and so forth. If you're making it a 25-year starting point to use a weapon, then they can simply plan to strangle their victims. So it would never pass. I can't think how it could ever pass any gender impact survey, and it will simply heighten the gender divide. Now, I note the time. We made similar recommendations in relation to manslaughter, both voluntary in terms of the partial defences and the other forms of manslaughter, unlawful act and gross negligence manslaughter. And that, of course, comes within the remit of the Sentencing Council. They have adopted, I think they've agreed to adopt the, they have agreed to adopt the coercive control as something which indicates higher culpability or mitigates culpability in cases of manslaughter. And in cases of, they consulted on that as part of their miscellaneous provisions, I think. And in cases of, I think strangulation was to be an aggravating factor. So I'm not sure that they were, I'm not sure that they were convinced, but they did consult on it. I think there's generally a positive response to that. And the reasons for the mirror provisions are, it's important obviously to have a consistent policy. Here we are, we've got the response of the Sentencing Council. So they consulted on strangulation, suffocation and asphyxiation as being a factor leading to greater culpability. They consulted on proposal to include coercive control in the guidelines, agreed to adopt those changes, and previously decided not to act on a recommendation as to the use of weapons. So their response is consistent with the government response on that in relation to murder. And not to act on recommendation 16. So I'm just going to quickly deal with that. We recommended, so when we were looking at manslaughter, we also looked at something which has become known kind of amongst academics and campaigners as the rough sex defence. So where women are killed during the course of a sexual encounter when there's been consensual violence during that encounter. And what we said was that the offender, when he's charged with unlawful act manslaughter or gross negligence manslaughter, one or the other, the killing should also always be categorised as category B, at least so higher or high culpability, and not medium culpability. And the reason for that is that where strangulation, for example, is practised, it didn't happen in any of our cases, but we had very much in mind the case of Sam Pybus, who strangled Sophie Moss when during the course of what was said to be a consensual sexual encounter. We took the view, and many of the many doctors who've done research on it, that the risk in non-fatal strangulation, even if it's consensual, is extremely high. So the court in Pybus and the guidelines distinguish between an obvious risk and a high risk. And our view is that that's a legal nicety, really, when you're looking at that sort of activity. And anyway, the Sentencing Council chose not to act on that, saying that there was not a sufficient evidence basis. But the government have now announced, I think they announced on the 14th of February that they are going to act on that recommendation. And as I say, there's been separately a campaign on those issues, on the issues of the rough sex defence. And they say it's consistent, and of course it is consistent, with their policies on with the law on non-fatal strangulation, which is now an offence. But it's not consistent with what they're proposing in the latest review. So query how that can, how in any way that can be consistent or provide gender equality. And I was asked to look at defences as well, but there simply wasn't enough time or resources to do that. And anyway, it's such a complicated area that I recommended there should be a full consultation on that, a full and proper consultation, widespread consultation on that. And I'm pleased to say that the government has referred the whole issue to the Law Commission. And so hopefully they will look at it and look at the comparative law on the issues. And the final chapter of the paper deals with the issues, if you're interested, in terms of the difficulty with defences, particularly for women. So the remaining questions, I think, in terms of the law, how satisfactory it is principally how fit for purpose is loss of self-control. The Court of Appeal made the point as long ago in 2012 in Clinton that there was no special provision for the gender of the defendant. In the review that we did, and obviously we're only dealing with sentencing, but you can't look at sentencing in a vacuum without looking at the facts, there were only 2 cases where loss of control had been successfully relied on by the women in those in the survey parameters. One of them had to be retried because the jury couldn't decide in the first instance, and she was retried by the Crown and eventually quitted on the basis of loss of control. But the sentencing remarks make it clear that there was a blurring of the trigger. So the issue is how fit for purpose. I think that's the headline in terms of the defences, if they are going to be looked at by the Law Commission. Case of Jackson was something, she was refused, Penelope Jackson was refused leave on the summing up didn't really divide trigger circumstances and so forth. In my submission, Court of Appeal said there was nothing in it and she was refused leave. And so one wonders whether we not just because we lost the case, but whether or not we need to look at loss of control carefully. We need to look at whether or not the experiences of women in controlling and coercive relationships can actually translate properly into a defence which ought to be there for them, but which is being designed without any consideration of the law as we know it. Issues in terms of defences for psychiatric conditions are conditions like depression, post-traumatic stress disorder. I've said they're probably an output of coercive control a lot of the time. Are we over-relying on psychiatric diagnosis? And do we can we change that with what I would urge we should, which is a proper forensic understanding of domestic abuse by way of coercive control. Some recommendations. So the Women Who Kill document published by the Centre for Women's Justice, I've just referred to it there, and the Domestic Homicide Sentencing Review. That's the end.